next principle which I'm going to deal with is that prior use. So what is prior use? So in a trademark, there are two types of trademark in India. The marks which are already in use, the marks which are proposed to be used. What is proposed to be used? See, normally we all know that what is the mark in use. A trademark or any name or a company name which we are using already and which has been used in the course of the business. For example, I'm running a business, I have a trademark, I'm using it for the last 5 years, but I have not registered it. When I go for a registration in the trademark office, I can say, so I'm applying today in 2020, I can say that I've been using this mark from 2015. So that is called mark which is in use, marks which are in use. What is proposed to be used? I have an idea to start a company. I have an idea to start a brand, but not now, maybe in another 1 year or 2 years. So what I can do, instead of just waiting for another 2 years or 3 years after I start the business and go and apply for a trademark, I also have a right to register a trademark even now, even if I'm not starting the business now. I can start after 2 years or 3 years. That is called the marks which are proposed to be used or intent to be used. I'm having an intention to use. That is called intent to be used. In these kind of cases, when there are two conflicting marks, it is always the major principle for the courts to decide. When there are two marks, the courts will decide based on the concept of prior use. What is prior use? It is like a first come, first serve. Who started first? Who is prior in the use? For example, if there are two trademark, there are two parties using the same trademark or a similar trademark. When the matter comes to the court or even in the trademark office, what is the deciding factor? The deciding factor is the court or the trademark office will see who started first. The party who started first is having the right to use the trademark. Suppose if the party who started first is giving an NOC, no objection certificate, or is willing to coexist it, then he can give a certificate or a letter to the other party to coexist or to register the same trademark by giving the no objection. But the rule says the party who is using prior is the right party to continue with the use of the trademark. Now here there is there is a landmark judgment. This judgment is called Dhariwal Industries Limited, as MSS Foods Products. The citation you can note down, 2005-30 PTC 233. So we all know there is a Kutka called Manik Chand. So this is the case about that Manik Chand Kutka. And in fact, it was an eye-opener in the field. Because normally there is a belief that trademark is a certain matter of big companies or multinational companies. But in fact, it is not so. Even WIPO, the World Intellectual Property Organization, is having a specific schemes and special schemes for MSMEs, small, micro, and medium enterprises. And they have given various benefits for MSMEs for registering their IP, either it is a trademark, patent, or copyright. So here is the case which will help you, irrespective of the size of the company, irrespective of the revenue they generate, irrespective of the popularity they have. When there is a fight between two companies, one is a multinational company and one is a normal company, which is very, very normal, very small in scale. It is not that the bigger company will win. Here, the trademark law will help even for a smaller company if you show that you are the prior user. Though it is not pan-India, This is classic case of fire use. The facts of the case is that Dariwal Industries Limited filed a suit. Dariwal Industries is the bigger company. MSS Foods product is the very small company. Dariwal Industries filed a suit against MSS Food product for using the name Malik Chand. You can see it is not Manik Chand, it's Malik, M-A-L-I-K, Malik Chand, which is identical to the trade name of the plaintiff Manik Chand. Wrongly and fraudulently, with an intention to ride on the goodwill of the plaintiff and to protect their right, plaintiffs have filed a suit in Bombay High Court. So the bigger company, Dariwal Industries, they file a suit in Bombay High Court. And they think that we are a big company and we have a huge reputation, huge publicity. And they file a suit against a normal company, very small company. But what happened is very interesting. MSS Food Products sued in turn like a counter blast. This company sued Dariwal Industries and Rasiklal Manikchand Dariwal. These are the two parties in the case for Manikchand. The Court of First Additional District Judge, Mandaleshwar, West Madhya Pradesh. It's a very small city in Madhya Pradesh, and they file a suit in the district court for declaration that the defendant do not have any right to use the mark Manikchand to sell masala, pukka, supari mix or any other goods which is deceptively similar to the mark Manikchand. Like they filed a suit, he also is filing, this small company is filing a suit against the bigger company saying that they cannot use the word Manikchand because it is similar to our trademark, Malikchand. And for perpetual injunction restraining the defendant from dealing in or selling above articles under the name of Manikchand. And they also ask for the rendition of accounts. In the case of the plaintiff says that the smaller company, Prabhudayal Chobe, son of Ram Prasad alias Manikchand, started the business of supari, that to Ayurvedic pan masala, Ayurvedic medicines in the brand name Malikchand in the year of 1959 and 60. So in a remote place, they started this business in 1959 and 60. And thereafter, one after another, they do the business till 92 they come. After 30, 40 years only, the bigger company finds him. That too, they don't even have a knowledge. The small company is doing a business in a small circle, but for a longer period. Somehow they got to know this and they file a suit in Bombay High Court. And here they file a suit in the district court. There are two suits here. Now we will see what happened in this case. It is further case of the plaintiff that the defendants have started selling gudka, pan masala, supari, sarda in the name of Manikchand, phonetically similar to the plaintiff Malikchand, and thereby passing off their goods as that of plaintiff goods. And there is another allegation that the plaintiff alleged that defendants have been selling the inferior quality goods, resulting in huge losses to it. The small company is not only saying that they have copied our trademark, they are also saying that the quality of the pan or pukka, zarda is inferior quality. The defendant take the defense and they file a written statement as usual. They disputed the plaintiff claim or prior use and averred that the name of Prabhudayal father was Ram Prasad, not Malikchand. They are saying that no, your name itself is not Malikchand. They denied that any business was run by Prabhudayal Chaudhary in the name of Malikchand. On the other hand, the defendants claimed way back in 1966, an application for registration of trademark Manikchand was submitted. In 66 itself, they are saying that the defendant, we have also filed an application for registering our trademark Manikchand. Because they are saying defendant number 2 father was Manikchand. And they have been doing their business of supari, gudka, tobacco in the name of Manikchand. but you can see the year is 1966. But there, though it is a small company, they say 59 and 60. So there is a gap of 6 years. The beauty is that, so many friends, when they ask for a trademark doubts, they always say that, can we go for a legal action when the mark is not registered? Like I said in the previous case last, what will happen when both the marks are not registered, but both the parties are using the trademark? Whether one party can challenge the other party, can I file a suit? So all these questions will come up. But this is the example for this case. Here they say neither party had a registered trademark. Neither the plaintiff nor the defendant has a registered trademark. The respective mark claimed by them. But they have filed an application. Both of them have filed an application. The applications are pending. As on today, at the time of the suit, nobody had a registered trademark. Now we will see what the trial court says. The trial court says the plaintiff has prima facie established prior user. This is what the concept of prior user. I have already mentioned about the comparing of 2 years. One is 5960, the other one is 66, though if it is admitted. In fact, they are saying they have started only 90 years, 1990, something like that. Even if they claim that they have filed an application in 1966, when you compare 1959 and 66, 1959 and 60 is the prior. So the prior user is already been established by the plaintiff for the Malik Chand. And it observed that the question whether the assignments relied on from the predecessor, the plaintiff were genuine and pre-proved and are proved that proved to be genuine was a question that could be decided at the trial, and this prima facie case stay. There was no reason to discard those documents. They are saying that the defendant are questioning the assignments which were submitted before the court. As I said, in 1959, one Prabhudayal Chowdhury started, and after that, the family, like a hierarchy, the next generation is taking. There are some assignments. So this is also a very important concept. We may think that the assignment of trademark. What is assignment of trademark? Like in the property matters, when I have a property, I am selling it. So there are various ways of conveyancing, sale deed or a settlement deed or a partition deed to just to there is a title is being transferred, and there is a sale, the title is being transferred, and there is a settlement, the title is being transferred. Similarly, trademark or copyright, any IP, the title also can be transferred by way of an assignment. There is a question that whether only a registered trademark can be assigned or even an unregistered trademark can be assigned. But in this case, we could see that even in 1960s, they have done assignments for unregistered trademarks. The court says that though it is a family hierarchy, it was given to one to another, the assignments of unregistered trademark is also valid. The legality, the originality or the authenticity of the document can be tested only during the trial. But prima facie, it seems that there are assignments, so we cannot negate the fact that there are assignments, and they have been using the mark from 1959 or 60. So they say the trial court says there is a prima facie case. Now we will see what the high court says. The appellate court observed that the trial court at this stage was not wrong in coming prima facie to the conclusion that the prior user of the mark was by the predecessors of the plaintiff and the plaintiff. Predecessors in the sense, their forefathers are the ancestors. When the suit was filed, it is not the original party because it started from 1960. So it's like a fourth generation or fifth generation. So the plaintiff has not started on his own from 1960. The plaintiff's predecessors have started in the 1960. It is coming like that till today. Regarding the argument based on the delay and latches, of acquiescence. The appellate court took the view that the present action was triggered off by filing the suit by the defendant in the High Court of Bombay. They are taking the defense called acquiescence. The defendants say that we are a bigger company and the plaintiff is a small company. They are operating in a remote places. And we being a bigger company and we do all kind of advertisement because we all know that Manik Chand is a bigger company and even in Tamil Nadu there are various in every pawn shop if you go we can find definitely Manik Chand good car whatever it is despite the ban. So the defendant is taking the stand that the plaintiff definitely should have known about our presence. They should have known about our business and even after knowing all these things they kept quiet. They have not taken any action. So this delay in taking legal action against us will amount to acquiescence. It shows that they know our presence and they are okay with that. So because of this, they cannot take any action. That is what the contention of the defendants. Thus, the High Court says, finding no reason to interfere with the grant of interim injunction, the trial court, the lower appellate court dismissed the appeal filed by the defendant and directed the trial court to try and dispose of the suit within a period of 6 months. So even the High Court says that no, this delay cannot be accepted, and we see that they are the prior user. That is what is very important in this case. As I said in the beginning that it is not about bigger company or small company. You do advertisement all over India, nothing. Even if it is a small company, even if they sell it in a smaller scale, who started first is the main thing. So High Court is also accepting the view. Now again the bigger company is going to Supreme Court. Supreme Court is giving a various guideline for this and it says that Section 27 of the Trademarks Act provides that nothing in the Act shall be deemed to be affect the rights of action against any person for passing up. Goods or services as the goods of another person or as services by another person are the remedies in respect thereof. Therefore, the fact that neither party has registered a trademark as on the date of the suit cannot stand in the way of entertaining the claim of plaintiff and granting the plaintiff an injunction in case of plaintiff is in a position to show prima facie that it was a prior user of the mark. Had a prima facie case, the balance of convenience was in favor of the grant of interim injunction. And this is also an important point. Section 39 of the Act, an unregistered trademark may be assigned. So they raised this question also. The defendant raised that when the mark is not registered, how can they do assignment? The Supreme Court says, as per Section 39, even an unregistered trademark can be assigned or transmitted with or without goodwill of the business concerned. It is therefore possible for a plaintiff or a defendant to show that an unregistered trademark that was being used by another person earlier had been assigned to it and that it can take on the prior user of its predecessor. When you claim prior user, it's not that I have to personally use it. The Supreme Court says that you can, like how we have the property chain, the grandfather to father and father to son, like that. The trademark also is like it's a property. That is why it is called as intellectual property. It is not that if I am continuously using, I have to personally continuously use. I can take the chain of my forefathers, grandfather to father, father to me. That is what it says. So who started first? The date of the first use is very important to decide any trademark dispute. The principles governing the grant of interim injunction are well settled and do not require to be repeated. Interim injunction has been granted in favor of the plaintiff in this case, mainly on the finding that there was a prior user of the mark Malik Chand. If not by the plaintiff, by his assigners, the use of the mark Malik Chand by the defendants in respect of Pan Masala and Kutka and Supari commenced only at a later point of time. Prima facie establishment of prior reserve goes a long way in enabling the plaintiff to claim an injunction in the passing of action. Finally, the court says, prima facie it appears as that the mark Malik Chand was being used, though not much publicized by the original user, leading to the alleged acquisition of the right to use the mark by the plaintiff. The defendants appear to have started the use of the mark Malik Chand at a large scale subsequent point of time. So you can note down these two lines. Malik Chand, not publicized, very small scale, but they started first. Manik Chand, this large scale industry, very publicized, and they have a huge advertisement, big company, all over pan India publication, pan India business, but they started at a later point of time. This is what the court says. Based on the prior user concept, the plaintiff wins the case, so it is a small company. So IP is a kind of, as I told you in the beginning, that IP is not a matter, a subject matter for only bigger companies or only multinational companies. The intellectual property right always held even for a smaller company, even small, medium enterprise.